Thank you, Madam President. First, let me thank the distinguished senator from Illinois for his statement. We served together on the Judiciary Committee, and I hope that in that committee as well we can work on ways to improve the prosecution of particularly rape offenses within the military by the Department of Justice and break through the agreement that now prevents the Department of Justice from prosecuting those crimes for the crimes that they are simply because they take place in the military. I'm here to speak today because Washington, D.C. and the right-wing outrage machine are all abuzz about the scandal that the IRS appears to have targeted organizations for inquiry based on Tea Party affiliation. Obviously, that's wrong. But let's not forget, that's not the only IRS scandal. That is not the only scandal in town. There are two IRS scandals. The other is the IRS allowing big, shadowy forces to meddle in elections anonymously through front groups that file false statements with the IRS. Let's go through this. Let's begin with the principle that it's pretty clear that Americans have a strong interest, a strong democratic interest in knowing who is trying to influence their vote in elections. That's kind of democracy 101. Even the Supreme Court, which can hardly agree 8-1 on what time it is, agreed 8-1 that knowing who's trying to influence your vote is really important. Here's what they said. They said that effective disclosure would, quote, provide shareholders and citizens with the information needed to hold corporations and elected officials accountable for their positions and supporters. Very much part of the democratic process. But some folks don't want you to know who they are when they meddle in our politics. Big companies taking positions that would annoy their shareholders or their customers. Secretive billionaires who want influence without accountability, who want to pull the strings behind the scenes. Polluters, Wall Street, big oil, and other folks that the public is fed up with, they all have lots of reasons for wanting to stay secret. But the law in America requires lots of disclosure. And the Supreme Court has emphasized the importance of lots of disclosure. So, what's a company or a billionaire trying to hide their influence seeking going to do? How does the secret money get in? Well, easy. You create a front organization, usually with a phony baloney happy name, and you hide behind that. Except it's not quite that easy. There aren't that many kinds of organization that can hide their donors that way. The most commonly used is called a 501c4, which is a tax-exempt, nonprofit form of corporation that is regulated by, guess who? The IRS. There is one big problem for people wanting that secret influence in politics, and that is that that kind of organization, the 501c4, needs to be set up, this is the law, quote, for the promotion of social welfare. Indeed, the law says exclusively for the promotion of social welfare. And according to the IRS's own regulations, quoting again, the promotion of social welfare does not include direct or indirect participation or intervention in political campaigns on behalf of or in opposition to any candidate for public office. So that's a problem. Well, the first kind of mini scandal is that the IRS has decided that an organization is organized exclusively for the promotion of social welfare if it is primarily engaged in social welfare activities, and that primarily means 51%, so the other 49% can be purely political. So, does not include direct or indirect participation in political activity has been turned into actually does include, but up to 49%, which is nonsensical. And that, as I said, is a mini scandal of its own. But let's go on. The IRS allowing a bunch of political operatives to form nonprofit groups that don't disclose its donors and then collect millions of dollars and spend them on elections in contravention of a clear statute and seemingly in violation of their own rules also requires that they usually make some false statements. That's where the scandal really worsens. There is a form called the 1024 form that is the application form for 501c4 status. If you go to that form, you'll see question 15. Question 15 asks this: has the organization spent or does it plan to spend any money attempting to influence the selection, nomination, election, or appointment of any person to any federal, state, or local public office or to an office in a political organization? That's the question on the form. It has to be answered under oath. A considerable number of groups appear to have lied on their applications for nonprofit status and on their returns, and they have lied with absolutely no consequences. There is a Pulitzer Prize-winning, nonpartisan investigative group called ProPublica. ProPublica has investigated these 501c4 filings. As part of their investigation, they looked at 104 different organizations that had reported to the Federal Election Commission or to the state equivalent federal elective bodies, 104 organizations that reported electioneering activity, that they were involved in trying to elect candidates. And in those filings to the federal and state election boards, they said, here is what we spent on influencing those elections. Well, ProPublica cross-checked those 104 who had filed statements saying how much they had spent to influence elections, and 32 of them had told the IRS that they spent no money to influence elections, either directly or indirectly. Both statements cannot be true. You cannot tell one federal agency how much you spent to influence elections and tell another federal agency that you spent no money to influence elections and have both statements be true. And then you look at these organizations' behavior, and the false statements look even worse. One organization said that it would spend 50% of its effort on a website and 30% on conferences. The investigation showed its website consisted of one photograph and one paragraph. No sign of any conference. The same group declared that it would take contributions, quote, from individuals only, and then took $2 million from pharma, the pharmaceutical lobby. Another declared to the IRS that it had spent $5 million on political activities, but it told the Federal Election Commission it had spent $19 million on political advertisements. Another pledged that its political spending would be, and I quote, limited in amount and will not constitute the organization's primary purpose. And then that organization went out and spent $70 million on ads and robocalls in one election season. It's almost funny, it's so bad. But there's nothing funny about making a material false statement to a federal agency. That's not just bad behavior, it is a crime. It is a statutory offense under 18 United States Code Section 1001. The Department of Justice indicts and prosecutes violations of this statute all the time. But they never do for this. Never. Why? It appears that there is a bad agreement between the Department of Justice and the Internal Revenue Service that the Department of Justice won't prosecute false statements if they're made on this form, unless the case has been referred to them by the IRS. So that's really scandal 2 right there. No matter how flagrant the false statement, no matter how great the discrepancy between the statements filed at the IRS under oath and the statements also filed at the federal and state election agencies, no matter how baldly the organization in practice contradicts how it answered IRS questions about political activity, the IRS never makes a referral to the Department of Justice. 32 flagrantly false statements, and as far as anyone knows, not one referral to the Department of Justice as a false statement. It is a mockery of the law, and it is a mockery of the truth. There's an easy solution. The Department of Justice prosecutes these false statements in lots of other instances. Prosecute these. Juries are good at sorting out what's a lie and what's not. Investigations, interviews, statements, and subpoenas can look behind what appears to be a false statement, and prosecutors can get a full sense of the case in a grand jury before any charges are finalized. But they can't if they don't even look. Right now, organizations, multiple organizations, lie with impunity and in large numbers. And it is indeed a scandal that the IRS won't even make a referral. Frankly, it's no great credit to the Department of Justice that the department won't act on its own with all of this so public and so plain. Hiding behind their agreement with the IRS on these facts is not that great department's finest hour. So, it is very wrong. It is very wrong that the IRS required additional information from a number of organizations, mostly small organizations, based on a screen that incorporates those organizations' Tea Party orientation. It is very wrong. But it is also very wrong that the IRS goes AWOL when wealthy and powerful forces want to break the law in order to hide their wrongful efforts at secret political influence. Picking on the little guy is a pretty lousy thing to do. Rolling over for the powerful and letting them file false statements is pretty lousy too. 2 scandals. Let's not let one drown out the other. I yield the floor.